In one case, the father, who is in his early 70s, sadly has an advanced case of Alzheimer's. He can't take care of himself. So his son has taken care of him, gave up his job, moved into the home, and he's been there 5-6 years, taking care of his father, taken like a nurse. But the sister doesn't like that. The sister's jealous of the brother and wants to get really control of Dad's money. So now we're fighting over which one of them will be guardian. So you have a whole trial in probate court over who's going to be the guardian. Now, if you plan, you can say in advance while you're healthy, if I ever need a guardian, here's who I want to be my guardian, and you can take care of that. But the other case is another greed case in which a gentleman who's in his early 80s, and he does have Alzheimer's, but it's an early Alzheimer's, and he takes care of all his business and his 12 rent houses and mows his grass and lives alone and lives a nice life and is active in his church. But his 2 greedy children have filed to try to get a guardianship against him. Why? They want to take over control of his money. It's human nature is sad, but you see these things. So you can, even under the probate code, you can do an advance designation of the person you want to be your guardian if it ever becomes necessary. All right, now, what's a way to get around the issues of guardianship? You can do it through less restrictive alternatives to guardianship, and that's through a power of attorney. Power of attorney. You can designate someone to be power of attorney, and that's really you're appointing an agent, aren't you? Someone to act for you. If you're out of town, or even if you become incompetent, if you make it a durable power of attorney, you name someone, then they, even if you become incompetent, can sign papers for you, transact your business. You can also separately designate someone as your health care power of attorney. There may be physicians in the room that are familiar with the HIPAA standards and the confidentiality and right to privacy of medical communications and medical records. And if you have the health care power of attorney where you've named your spouse, a child, a brother, someone to be your health care agent, that person then can give consent for medical treatment and can also have the right to communicate with your physician and be a liaison with the physician. Otherwise, the healthcare providers feel that their hands are tied because of this HIPAA prohibition against sharing information. It becomes very difficult. So part of the planning is to have a statutory, durable power of attorney and a healthcare power of attorney. One final document in this planning is a directive to physicians. We used to call it a living will, but it's a document in which you, while you're healthy, say, if I ever become terminal with an incurable condition, no hope of recovery, and I'm merely being kept alive on a ventilator, it's my desire that I have that ventilator removed and I be allowed to die only with morphine or pain medicine, but not be kept artificially alive in a vegetative state. And the healthcare profession finds it necessary to keep providing everything that's available to keep that body going, including a ventilator and a feeding tube, if you haven't made that designation. And some of you may be familiar with the Terry Schiavo case from Florida a few years ago. It was in all the news, kind of an intersection of politics and religion in this case in which the woman had been in a vegetative state for at least 8 years, a long period of time. And her husband said she didn't have the directive to physicians, but her husband said that's what she wanted. She would not want to be laying there with a ventilator. And the woman's family contested that, and there was a big, it was on the news. You have politicians saying, well, she looks like she's alive to me, and she's smiling in the camera, and all ridiculous things. And finally, the court allowed the ventilator to be removed, and she died promptly. And the autopsy showed that she had what pathologists call a Swiss cheese brain. I mean, big holes in her brain that had been there for all that time. She'd never been able to think or really be alive. So if she'd had the directive to physicians, all that anguish that the family went through, it was just terrible. Right or wrong on either side, it was very traumatic. So a directive to physicians is an important document. The cost of probate. You may have been to seminars or heard people try to tell you that probate is so difficult and expensive and you should create a living trust, a inter vivos trust, or a trust while you're alive. And so you create a trust, which is like creating a corporation, and transfer your property into that trust while you're alive. And there may be reasons for that, but in Texas, most of the lawyers say, really, you don't need that if it's only to avoid probate. The cost of probate could be typically, it could be more, depending upon what had to happen. But if you're just probating a simple will, it's probably $1,200 to $1,500, which is a lot of money, but there's 200 and some odd that you pay the court clerk, and there's another $84 you have to pay the newspaper to publish a notice to creditors, and then the rest of it's about probably $800 to $1,000 attorney fee by the time you get through. And that's cheaper than creating this living trust and then having to administer it, because when you create that trust, it has to have a separate tax ID number, has to file a separate tax return. Everything has to be run through that like it's a corporation. So, and you lose control to a certain extent. So I'm not saying we don't need those kinds of documents, but not for the purpose of avoiding probate. Probate is not a complicated process if you have a proper will. If you don't have a proper will, yes, now the lawyers can make some money on that deal. There's a lot more to do. Yeah.
So does trust protect the liabilities, or what is the use of the trust? Not just leaving the properties.
Yeah, for liability purposes. There may be a reason that you want to have a living trust, inter vivos trust, so that you don't own this property. If it's an irrevocable trust, if you can't change your mind and take it back, you've given it up. So if the property's in the trust, then that could protect you if you get sued and there's a big judgment. You don't own it anymore. The trust does, the family trust. And so that would be one reason to do this. Let me make one, I'm sorry, Chief. No. One final point. And I'm not sure if Mahesh mentioned this a while ago or not. For estate tax purposes, the current law is, I think this will be the law for a while, if your estate is under $5 million, and actually it increases with the CPI. So this year it's $5,250,000 exemption. So if it's under that, we don't have to pay estate taxes. Now, and also for any transfer to your spouse, there's no estate tax involved there. So even if it's more, so long as you give it to your spouse, it's not taxed at that time. So probably all of you need to worry about that with the state's over $5 million, but the common person doesn't have to pay an estate tax. It's only a small percentage of people in this country that do. I think that's it.
Actually, can we do this, please? We have again, Mr. Thorne, if anybody wants to contact him for any of your will and estate needs, please contact his office, 972-264-1614. What we will do is, we'll take